Greetings to all. I hope everyone is doing well. I, Dr. Shikha Dhiman, Assistant Professor, Department of Laws, Guru Nanak Dev University, Amritsar, will be presenting on the topic Critical Evaluation of Doctrine of Judicial Review and its Application in India. Let's begin with an introduction. The doctrine of judicial review is a fundamental concept in constitutional law. It empowers the courts to examine the constitutionality of laws passed by the legislature and administrative actions. In India, this doctrine plays a crucial role in upholding the supremacy of the Constitution and protecting citizens' rights. The doctrine of judicial review is a cornerstone of constitutional democracies, serving as a critical check on the powers of the legislature and executive. In India, this doctrine is not only a testament to the foresight of the framers of the Constitution, but also a reflection of the dynamic interplay between law and society. The Indian judiciary, through its power of judicial review, has the profound responsibility of interpreting the Constitution and ensuring that the laws and actions of the government align with the fundamental principles enshrined within it. At the heart of judicial review lies the supremacy of the Constitution, which is considered the ultimate law of the land. The Indian legal system, drawing inspiration from both its colonial past and the principles of common law, has adapted the doctrine to fit its unique socio-political context. The power of judicial review in India is vested in the judiciary, with the Supreme Court as its apex, followed by the high courts at the state level, and of course, other subordinate courts. The evolution of judicial review in India can be traced back to the landmark cases that have shaped its contours and expanded its reach. Starting with the Shankari Prasad case, where the Supreme Court first asserted its power to review constitutional amendments, to the case of Keshwananda Bharati, which established the doctrine of basic structure of the Constitution. Judicial review has been instrumental in preserving the ethos of the Constitution. The application of judicial review in India encompasses a wide array of issues ranging from the protection of fundamental rights to the interpretation of legislative enactments and administrative actions. It acts as a guardian of the Constitution, ensuring that the rights of the citizens are not infringed upon by arbitrary state action. The judiciary, through various judgments, has also laid down the grounds for judicial review, such as violation of basic structure, infringement of fundamental rights, and lack of legislative competence. Moreover, the Indian judiciary has adopted a proactive role in the application of judicial review, often stepping into the domain of public policy through public interest litigations. This activist approach has been lauded for its role in social change and critiqued for overstepping the boundaries of judicial function. The doctrine of judicial review in India is also influenced by many international legal provisions and statutes. The Indian judiciary has often referred to international conventions, treaties, and the jurisprudence of foreign courts to enrich its understanding and application of judicial review. This cross-jurisdictional dialogue has contributed to the development of a more comprehensive and inclusive legal framework. The doctrine of judicial review in India is a complex and evolving instrument of justice. It has been pivotal in upholding the Constitution and protecting the rights of the citizens against the excess of state power. As India continues to evolve as democracy, the doctrine of judicial review will undoubtedly play a crucial role in shaping its constitutional and legal landscape. Now let's discuss about the origin and historical context. The doctrine of judicial review traces its roots to the United States of America. In the landmark case of Marbury versus Madison, the US Supreme Court established this doctrine. President Adams, on his last working day, appointed members of the Federal Party to 42 new positions as judges. However, President Jefferson, who belonged to the anti-federalist faction, opposed these appointments. Marbury, one of the justices whose appointment was cancelled, filed a writ of mandamus petition with the Supreme Court. Instead of directly hearing the plea, the court declared the legislative directive ultra-vires and unlawful, thereby establishing the doctrine of judicial review. The British legacy and early developments. The roots of judicial review in India can be traced back to the British colonial era. Under British rule, Indian courts followed the English legal system, which included the principles of judicial review as applied by the courts of England. However, it was not until after independence that judicial review became a defined feature of India's constitutional landscape. Now let's discuss as to what was the influence of American jurisprudence. The concept of judicial review in India was significantly influenced by the American model. The power of judiciary to review and invalidate laws that contravene the Constitution was first established in the landmark US case, as already discussed, that is of Marbury versus Madison of the year 1803. This principle was adapted to the Indian context, where it has played a pivotal role in maintaining the supremacy of the Constitution. Now, coming upon the enshrining judicial review in the Constitution of India. The Indian Constitution, as adopted in 1950, explicitly incorporated the doctrine of judicial review. It empowered the judiciary to invalidate laws and actions that violate the Constitution's provisions, thereby upholding the principles of justice, liberty, and equality as enshrined in the preamble. Now, let's have a view over the landmark cases shaping the judicial review. Several key cases have shaped the doctrine of judicial review in India. The case of Shankari Prasad versus Union of India, 1951, initially upheld the unfettered power of Parliament to amend the Constitution. However, this position evolved over time, with the Supreme Court asserting its power to review constitutional amendments in subsequent cases such as Sajjan Singh versus State of Rajasthan of the year 1965, Golaknath versus State of Punjab of the year 1967, and the historic, that is Keshwaranda Bharti versus State of Kerala of the year 1973. In the Keshwaranda Bharti case, the court established the basic structure doctrine, holding that certain fundamental features of the Constitution could not be altered by any type of constitutional amendment. Now, the expansion of judicial review. Over the years, the scope of judicial review in India has expanded. The judiciary now reviews not only legislative actions but also administrative actions. This expansion has been facilitated by various judicial pronouncements that have clarified and extended the reach of judicial review, ensuring the protection of fundamental rights and also the upholding of the rule of law. The doctrine of judicial review has been instrumental in shaping India's democratic fabric. It has evolved from its colonial roots through the influence of American jurisprudence to become a fundamental aspect of the Indian legal system. The judiciary's role as the guardian of the Constitution has been reinforced through landmark cases that have defined and expanded the scope of judicial review, thereby making it an essential feature of India's constitutional democracy. Now let's talk over the position of doctrine of judicial review in India. In India, the Supreme Court is the ultimate interpreter and custodian of the Indian Constitution. Its power of judicial review allows it to scrutinize and declare arbitrary or unconstitutional any legislative or administrative actions as void. Although the Indian Constitution does not explicitly mention this doctrine, but it is implicitly embedded in several articles, including Article 13, Article 32, 131 to 136, Article 143, Article 226 and 246. These provisions empower the judiciary to interpret the Constitution and strike down the laws that violate fundamental rights which are granted under Part 3 of the Indian Constitution. Now, let's come over to the constitutional provisions and its interpretation. Number 1, that talks about Article 13. This article plays a pivotal role in judicial review. It declares that any law that infringes the fundamental rights under Part 3 of the Constitution shall be void to the extent of such inconsistency. It also ensures that legislative actions are subject to constitutional scrutiny. Point number 2, that is Article 32 and Article 226. These provisions empower the Supreme Court and High Courts respectively to exercise judicial review. Article 32 grants the Supreme Court the power to issue writs for the enforcement of fundamental rights, while Article 226 provides similar power to the High Courts. And these articles also allow the citizens to directly approach the courts for the protection of their rights. Third provision that deals with judicial review is Article 21. The phrase procedure established by law as given under Article 21 serves as the governing principle for judicial review. It means that a law enacted by the legislature is valid only when the correct procedure is followed. If a law violates fundamental rights or lacks any procedural fairness, it can be declared null and void by the courts. Another provision, that is the doctrine of basic structure. Although not explicitly mentioned in the Constitution, the Supreme Court has recognized the basic structure of the Constitution as a limitation on the amending power of legislature. In the landmark cases like Keshavanda Bharati versus State of Kerala, the court held that certain essential features of the Constitution cannot be altered even through constitutional amendments. This doctrine ensures that the core principles of the Constitution should remain intact. Let's now discuss about some relevancy and the features of the doctrine. Number 1, defending the constitutional rights. The doctrine of judicial review ensures that legislative and administrative actions comply with constitutional mandates and ideas. It upholds the supremacy of the rule of law and protects the rights of the citizens. Number 2, applicability. Judicial review includes both existing and future legislation. Courts examine laws for conformity with the Constitution, thereby ensuring the validity. Third point, power of judiciary. Both the Supreme Court and High Courts exercise the power of judicial review. They can declare laws or action unconstitutional if they violate the constitutional provisions. Now, coming up to scope of judicial review. Legislative acts. Judicial review extends to examining the constitutionality of legislative acts. Courts can strike down the laws that violate the fundamental rights or exceed the limits set by the Constitution. This power of judicial review ensures that legislative actions should remain within the constitutional bounds. Second is the administrative actions. In the field of administrative law, the courts have the power to review the legality of actions taken by public authorities in the exercise of their statutory powers. This review includes preventing not only excess and abuse of power, but also the irregular exercises of power. However, the scope of judicial review in constitutional law is narrower and focuses on actions that are unconstitutional or ultra-vires the Constitution. Next point is about the higher courts. Judicial review is limited to higher courts, specifically the Supreme Court and the High Courts. Lower courts do not have the same authority to review laws or any administrative decisions. Now, let's discuss about the limitations of judicial review. Restricts the government functioning. While judicial review ensures constitutional compliance, frequent interference by the courts can hinder the functioning of the government. Striking down laws or administrative actions will definitely disrupt the governance and the policy implementations. Next point, the violation of separation of powers. The critics always argue that judicial review sometimes violates the concept of separation of powers. By invalidating the legislative or executive actions, the courts may encroach upon the functions of other branches of the government. Next point, setting the precedents. Judicial decisions create precedents. While this consistency is essential, it can also limit flexibility in adapting to changing circumstances. A rigid application of precedents may not always serve justice to the people. Next issue is the local public perception. Excessive judicial intervention can negatively impact local public perception. Citizens may perceive the judiciary as overreaching or interfering with democratic process. Another point, inability to overrule administrative decisions. Although judicial review can declare laws as unconstitutional, it cannot directly overrule any administrative decisions. Courts can only set aside the administrative actions if they violate the legal norms. Another point, judicial activism versus self-restraint. Striking the right balance between judicial activism, that is proactive intervention, and judicial self-restraint, that is deference to other branches, is challenging. Courts must avoid overstepping their boundaries. While judicial review is essential for upholding the constitutional principles, it must be exercised judiciously to maintain a delicate balance between the legal scrutiny and democratic governance. Now let's highlight some technocratic as well as activist approach. The doctrine of judicial review in India has been shaped by two distinct approaches. One is the technocratic model and the other is activist model. The technocratic model, judges as the technocrats. In technocratic model, the judges act primarily as technocrats. Their role is to apply established legal precedents, interpret the law objectively, and adhere strictly to the textual provisions of the Constitution. They focus on the literal meaning of the legal text and avoid subjective interpretations. Then is limited discretion. The technocratic judges hold a law invalid only if it clearly exceeds the powers vested in the legislature. They refrain from delving into policy considerations or broader principles beyond what is explicitly stated in the legal language. Another is British influence. India's early years after independence saw a technocratic approach which is influenced by the British tradition of parliamentary supremacy. Judges rarely questioned the legislative actions except on the grounds of ultra vires, that is, which goes beyond their powers. Another approach is activist approach, that is, the expansive interpretations. The activist model involves judges interpreting the Constitution expansively. They consider not only the letter of the law but also its spirit, intent, and the underlying principles. Activist judges are willing to go beyond the strict textual interpretations so as to achieve justice. Policy-driven. Activist judges may consider societal context, public welfare, and policy implications. They recognize that legal decisions can shape the future and advance the development of the law in proper direction. Next, molding of the law. Justice P.N. Bhagwati famously stated that judges have the opportunity to leap into the heart of legal darkness, and accordingly they mold the law. Activism allows the judges to shape legal principles even when precedents and common law principles are insufficient. But what is the need? The need is for the balancing act, and for that there has to be judicial restraint. While India's constitution contains a Bill of Rights, in Part 3, the framers ensured that courts remained auditors of legality. The rights were precisely defined, leaving minimal discretion to the judges. The term due process of law was intentionally avoided to prevent excessive judicial intervention. What is the popular profile then? This expansion of judicial review, as often described as judicial activism, has raised the profile of India's higher judiciary. However, striking the right balance between enforcing rights and respecting legislative intent remains a challenge. India's judiciary navigates between technocratic restraint and activist intervention, thereby ensuring constitutional compliance while advancing justice. Talking about the concept of judicial activism and judicial restraint, both play a very crucial role in shaping the Indian legal landscape. The judicial restraint, it is a theory of interpretation that emphasizes limiting the exercise of judicial power. Judges practicing restraint adhere strictly to constitutional and statutory mandates, avoiding personal preferences or policy considerations. They hesitate to strike down laws unless they are clearly unconstitutional. The approach provides for the legislative intent. Restraint-oriented judges rely on legislative intent, rely on stare decisis, and the strict textual interpretation. They avoid policy making. They refrain from settling new policies through their decisions, leaving lawmaking to legislatures and executives. Now let's have some views on criticism and the challenges. Separation of powers. Critics argue that the excessive restraint may undermine the principle of separation of powers. Limited adaptability. Strict adherence to precedent can hinder adaptation to changing societal needs. Talking about the judicial activism, its definition. Judicial activism signifies a proactive role for the judiciary in protecting citizens' rights. It involves interpreting the Constitution expansively, considering not only the letter of the law but also the spirit, intent, and underlying principles. How this was developed? It was coined by historian Arthur Schnitzler. The term gained prominence in India through justices like V.R. Krishna Iyer, P.N. Bhagwati, O. Chinnappa Reddy, and D.A. Desai. Activist judges go beyond the established norms to achieve justice, and accordingly, they address societal concerns. What is the importance and causes for that? First point, the executive and legislative failures. The judicial activism arises when other branches fail to act effectively. Human rights protection? Of course, judicial activism responds to the violation of basic human rights. Misuse of constitutional provisions? Definitely, the instances of misuse will lead to judicial intervention. Now, what is the role of judiciary as such? Judicial restraint. It upholds the stability, predictability, and democratic self-governance. And judicial activism, it addresses gaps, protects rights, and advances the justice. Now, let's discuss what is judicial overreach. When activism goes too far and interferes with the legislative or executive functions, when it breaches the principles of separation of powers, when the India's judiciary navigates between restraint and activism, it ensures the constitutional compliance while addressing the societal needs. Now, what is the impact on democracy and the protection of rights? The doctrine of judicial review significantly impacts democracy and rights protections in India. It's safeguarding the democracy and balancing of powers. Judicial review ensures a delicate balance of power among the three branches of government, that is, legislature, executive and judiciary. By scrutinizing the legislative and executive actions, the judiciary prevents any one branch from becoming too much dominant. Constitutional supremacy. The Indian Constitution is the supreme law of the land. Judicial review allows the judiciary to uphold constitutional supremacy by ensuring that laws and actions conform to constitutional principles. Then comes the rights protection. The judiciary safeguards fundamental rights enshrined in Part 3 of the Constitution. It acts as a bulwark against any infringement on citizens' rights by the state or other authorities. Then, impact on the rights protections. First is the expanding rights. Through judicial review, the judiciary has expanded the scope of fundamental rights. Landmark decisions have recognized new rights, including the right to privacy, right to education, and environmental rights. Striking down unconstitutional laws. When the laws violate fundamental rights, the judiciary declares them null and void. For example, in Keshavananda Bharati versus State of Kerala, the Supreme Court upheld the basic structure doctrine, ensuring that certain core principles of the Constitution cannot be amended. Then comes about the social justice. Judicial activism had led to progressive interpretations of rights. The judiciary has championed social justice by addressing issues such as bonded labor, child labor, environmental protection, and many more. Now let's talk about the challenges and criticism. Overreaching. Critics argue that judicial activism sometimes oversteps its boundaries, encroaching upon the domain of legislature and executive. Striking down the laws too frequently can disrupt the governance. Policy decisions. While protecting the rights, the judiciary occasionally makes policy decisions, and some believes that this should be legislature's role and not the judiciary's. Delays and backlogs. The judicial system faces delays and a backlog of cases. Activism may divert attention from clearing pending cases. Judicial review plays a pivotal role in safeguarding the democracy, protecting rights, and maintaining the constitutional balance in India. Now let's conclude the topic and give some suggestions to it. In conclusion, the doctrine of judicial review holds immense significance in the Indian legal system. As we critically evaluate its application, several key takeaways emerge. Number one is the balancing act. The judiciary exercises the power of judicial review with restraint and respects the principles of separation of powers, while at the same time ensuring the constitutional compliance. It also acknowledges the democratic role of legislature and executive. Then is the protection of rights. Judicial review acts as a bulwark against arbitrary legislative and administrative actions. By striking down unconstitutional laws, the judiciary safeguards the citizens' rights and upholds the supremacy of Constitution. Then is the expanding horizons. Over the years, the judiciary has expanded its scope of fundamental rights through activist interpretations. New rights such as right to privacy, environmental rights, right to education, and so on have been recognized. Now, what are the challenges to that? However, judicial activism must be balanced with caution. Overreach can always disrupt the governance, and excessive intervention may undermine the separation of powers. So, here are some suggestions that can be provided. Number one, judicial training. Continuous training for judges on constitutional principles, human rights, and evolving legal norms is essential. This will ensure informed decisions and consistent jurisprudence. Timely disposal. Addressing the backlog of cases and ensuring timely disposal of matters is critical. Efficient judicial processes enhance public trust in the system. Next, public awareness. Educating the citizens about their rights and the role of the judiciary fosters a better understanding of judicial review. Legal literacy programs can also empower the individuals. Next point, collaboration. The judiciary, legislature and the executive should all together collaborate to strike the right balance. Dialogues and consultations can always lead to effective policy making and rights protection. Summarily, the doctrine of judicial review remains a cornerstone of India's legal framework, ensuring both constitutional fidelity and the justice for its citizens. Thank you everyone for your time and attention. We have discussed the entire concept in a short time, and I hope that the listeners have understood the topic. Stay safe, stay healthy. God bless you all. Take care.